So lawyers are liars. Let's intro with that. You know, we all know as attorneys that we have a certain reputation, and we bear the brunt of a lot of joking. And it reminded me of this scene. The managing partner is trying to convince Fred that he needs to drop a little white lie in the course of litigation. I can't do it. Fred, it's your duty to present the strongest case possible. The strongest case possible, consistent with the truth. Will you let the judge decide what's true? That's what he gets paid for. You get paid to win. If you insist that I take it to trial, I will represent Mrs. Cole aggressively and ethically. But Miranda, I won't lie. Then we'll just have to find someone else who will.
And so it's at that point, of course, where they go out and they find Jim Carrey, right, and his character who normally can lie with ease, but is having a little difficulty because of his son's birthday wish, and he can't do it that day, if you remember the story. So, but we wanted to kind of point out here that, you know, look at what Miranda's saying. Will you let the judge decide what's true? That's what he gets paid for, right? You get paid to win. You just get paid to get up there and to make the best case that you can, you know, ethics be damned, right? And so this is actually taken directly from the pages of Plato. If we go back, I mean, Socrates basically said that the sophists were just hired guns that were brought in to win a case. And so we see that in an exchange between Plato's character Gorgias and Socrates. So Gorgias says, what is there greater than the word which persuades the judges in the courts, or the senators in the council, or the citizens in the assembly, or at any other political meeting? If you have the power of uttering this word, you will have the physician your slave, and the trainer your slave, and the moneymaker of whom you talk will be found to gather treasures, not for himself, but for you who are able to speak and to persuade the multitude. Sorry, I can't quite read it there. I answered Socrates that rhetoric is the art of persuasion in courts of law and their assemblies, as I was just now saying, and about the just and the unjust. So that's his take, right? That his job is there. He has this. He's trying to justify what he does. He calls it an art, right, of rhetoric. Socrates responds: the rhetorician does not instruct the courts of law or other assemblies about things just and unjust, but he creates belief about them. So that, again, this is Socrates' take, that you're just making this stuff up. You're creating this belief. And so that's what he goes on here. He's going to call it flattery. In my opinion, then, the whole of which rhetoric is a part is not an art at all, but the habit of a bold and ready wit which knows how to manage mankind. This habit I sum up under the word flattery. So you're not actually instructing about the truth. You're not instructing you're not really teaching the courts anything. You're just trying to win them over and persuade them. Now, even earlier than Plato, we have Euripides noting that it was from the noble families that this evil first started, and when shameful things seem to be approved by the fashionable, then the common people will surely think them correct. And I think that is basically the point that we've arrived at today, right? Did I go the wrong way? Sorry. Yeah, there we go. Okay. In which lawyers, liars, sophists, right? Is there really any difference between these groups or these monikers, right? And so that's, you know, I always like to tell people that when I told my dad that my dad's an oil field guy, you know, grew up in the oil field on the rigs, and very much just trusts lawyers. And so when I told him I was going to be an attorney, he said, okay, that's all right, but you know, is it all right if I tell my friends that you're a piano player in a whorehouse? And
So this is a persistent problem. It's the problem of rhetoric and those trained in rhetoric. We started with a clip from 1997, 20th century, all the way back to the classical era. Those who are entrusted with the powers of rhetoric and the ability to persuade and to use the coercive power of the state and the courts always run this risk of being perceived as a sophist, somebody who will manipulate language to achieve an end that may have nothing that may bear no resemblance to the common good or to virtue or the higher things. We started with a 20th century bookend. We went back to the classical era. John and I collaborated, and we asked ourselves, what is unique about the 21st century? If this is a nearly prehistoric problem, this problem of rhetoric and those trained in rhetoric, what makes it especially bad for our generation entering the 21st century? I was in law school until 2003, John shortly after that, so we're both 21st century lawyers, and we perceive there are at least 4 contributing factors to this problem of lawyers as liars, as sophists, people who just use words to achieve what someone pays them to achieve. The first negative factor is, of course, critical legal studies. We called them crits, and pretty sure most of the faculty at the University of Texas School of Law spent some time dabbling in this. And it was very fashionable, of course, in the late 20th century. In a nutshell, they were legal realists who said you should manipulate words. Words are social constructs. They are a mere pretext to power. With that reality, with that legal realism perspective, they thought it was perfectly fine to manipulate language and words. Also, this concept of a living constitution. I was fortunate enough to take separation of powers from Justice Scalia. I took his course in that subject matter, and he very proudly defended the dead Constitution to drive home the point that if you have this living, metastasizing thing, the written word has no binding effect on subsequent generations, and it gives no notice to those that are bound by it. The third effect, and this is more peculiar to my generation, Westlaw and Lexis. The advent of algorithmic word searching has induced what I call magic word briefing. So I noticed this as an assistant United States attorney. There was only one guy that used our library. His name was Fred Chapman, and he has since passed, but he was old enough that he still went to the library, pulled out a book, looked up the case, the head notes, and then argued by analogy, applying principles of IRAC, issue, rule, analysis, conclusion. I did not learn to do law the same way Fred did. Here's how I do law, or I was trained at least by my Westlaw Lexis trainers. Just keep hunting and pecking with some root expanders and exclamation points within 30 until you find some magic words. I would see it in the briefs that we would receive from opposing counsel, or even in briefing that we did at the U.S. Attorney's Office. There's this tendency to brief around magic words instead of thinking about the thing. You know, it's the famous quote from Oliver Wendell Holmes, think things, not words. I actually think this technological advantage has served to disadvantage, more classical forms of logic and rhetoric. And then legal and linguistic relativism. I would encourage you to read Professor Epstein's latest article. I think it's published in the Harvard Journal of Law and Public Policy, Linguistic Relativism and the Decline of the Rule of Law. Major political interventions were driven by a view of language that marks a sharp departure from the framers' confidence that the English language was clear enough to organize the fundamental institutions of government. The decline of intellectual rigor in the use of language leads to violations of the rule of law. In that article, he cites a couple examples. Harm. When that principle was first conceived in the Anglo-American tradition, it was from a Victorian era when harm took on a very physical substance. It's what we see in tort law, the slip and fall, you break something, something is physically altered. Today, it's mostly therapeutic. And you see these therapeutic psychological concepts working its way through the tort law. So linguistic relativism, the idea that any word can mean whatever the rhetorician says it is, I think that's contributed to this problem of lawyers and lying. So when I did not have the benefit of a Notre Dame education. There were no crucifixes on the wall at the University of Texas. So when I took professional responsibility, and the professors did their best to impart the importance of being a professional, they drew a stark distinction between law as a profession or law as a business. And I know there's some public choice theorists, and especially in the Chicago school, who still have this debate today. But in understanding lawyering as something different than mere business, this is how I was taught to think of the profession. It's a profession, which is different than a business. And this sort of distinction is not new to the 21st century. If you've seen Midnight in Paris, it talks about this glory day phenomenon where people look back at the bygone eras and think it must have been so much better then. This is actually an article from a law review published in 1914. So it's roughly 100 years ago. And notice that some of this profession-business divide existed even then. To quote, experienced lawyers bear witness to the metamorphosis of the legal profession to a commercial business. 25 years ago, the bar of New York City was eminently respectable. Today it is honeycombed with shysters, ambulance chasers, pettifoggers, persons unmindful or ignorant of tradition, bent with immorality and heedless or defiant of law. Men who value their rectitude more than their success are abandoning the profession. Many are being dissuaded from entering what is generally regarded as the graveyard of truth.
And if you look at that too, right, like, cover up the 1914 for a second, aside from the word pettifoggers, you could see this same quote coming up, right, someone making this statement in maybe 1980, 1990, 2000. It looks fairly modern because you're thinking like, oh yeah, it used to be that attorneys were respectable and this was a profession, but now they're just a bunch of shysters that manipulate these words, right? Like saying what we were just talking about, what we've seen in philosophy, right, where people teach, well, all these words have, it's all relative, right? And that's become the modern standard, right? But it's like I always told people, I used to be a youth pastor in a former life, right? And so I always say that, you know who the first relativist was? It was Pilate, right? When he has Jesus standing there before him, right? The incarnate truth talking to him, and Jesus explains it to him. And what does Pilate say? Well, what is truth, right? Yeah, and so it's all relative, and so that's what you get again. But that's what Matt was just saying. This isn't a new phenomenon. This is 1914, and we're seeing the same thing.
So, this is published, I believe, in the New York Journal of Criminal Law. I think it may be an expired publication, but you see here in 1914, professionals like us at the bar trying to mind the gap. How do we retain the sense of profession? And they are responding to the Industrial Revolution. Well, we can't let it commoditize. We can't let it become a business. Fast forward nearly 100 years, and this is from the Mirror of Justice blog from the pen of Professor Rick Garnett, who's quoting one of his students who wrote a really good paper on this.
Not me.
Yeah, I don't think it was you. We should never be complacent with the practices of our profession that conflict with its nobility, and as Aristotle would say, the architectonic role of the law. Practices like creative overbilling, just telling the client what he or she wants to hear, lax and minimalist ethical norms, and going along unreflectively while there are unjust laws that hinder human purpose, with the practices in our profession that have made it the butt of so many jokes. So this is a very modern concern, but it's referring to the same essential problem. Here in the state of Texas, most of you will be licensed by the Texas State Bar. We too have attempted to distinguish ourselves from mere businessmen, emphasizing professionalism. The lawyer's creed, which is non-binding but very aspirational. I'm licensed by the Supreme Court of Texas. I must therefore abide by the Texas disciplinary rules of professional conduct. But I know that professionalism requires more than merely avoiding violation of laws and rules. I am committed to this creed for no other reason than it is right. So look at that categorical imperative. I don't follow this for any sort of utilitarian reason. I do it because it is right. Now, what is capable of enforcing this sort of coda? The creed goes on to cite a couple of examples. My word is my bond, something like a no liar rule. I will advise my client that we will not pursue any course of action that is without merit. Truthfulness sort of rooted in that. I will not knowingly misrepresent, mischaracterize, misquote, or miscite facts or authorities to gain an advantage. The conduct of the lawyer should be characterized at all times by honesty, candor, and fairness. So if we're not a business and we are a profession, by what source do we derive these rules that are binding upon professionals in our profession?
Yeah, so you can see there, if you go back just one quick, there is the creed here is trying to capture a couple of things, right? That yeah, you're not going to knowingly misrepresent, mischaracterize, misquote. You're not actually going to lie. I think everyone could agree on that. That's what,
Not Pilate.
right, without Pilate. But that's part of what made the movie funny with Liar Liar, right? Is that everybody knows, okay, that's out of bounds. Right, but there's something more to it there. The conduct of the lawyer should be characterized at all times by honesty, candor, and fairness. So we're trying to get at something more than just the bare minimum of not lying, right? I mean, we should expect that from anyone. But there is something more. So that's where we get to the question today that Dr. Wolf presented us with is lawyering as a vocation. So what is a vocation? And now, I'm talking to the St. Thomas More Society, I think primarily here today, but it's kind of funny. I was talking to my wife last night, and she asked what the talk was on today, and I said, well, it's the vocation of a lawyer, and she said, and you're giving this to a bunch of lawyers, and I said yes, and being the of course true Protestant that she is, said, well, don't they know what that is, right? Like, because her only take on it is vocation is just a job, right? Like it's what you do. But I think there is much more of a deeper tradition than that. So if you just look at the dictionary, it lists a vocation as a summons or strong inclination to a particular state or course of action, especially a divine call to the religious life. Maybe an entry into the priesthood or religious order, or a separate definition, the work in which a person is employed, their occupation. Of course, that's what my wife was thinking when I said the vocation of the lawyer. But really, right, like it ought to be some combination of those two, right? Which is why we found this Fordham Law Review article, which any discussion of work as a calling or vocation necessarily will employ religious language and concepts. The very notion of being called, the vocation, implies a caller and has deep roots in the Hebraic tradition. So the idea is that your job, your vocation is a lawyer, but it's more than just a job, right? And of course, if you follow modern religious pop culture writers like Rick Warren, perhaps, you realize how he had made a fortune off of his books, like The Purpose-Driven Life, right? Like trying to tap into this idea that, right, that people, you have a purpose, there's more meaning to what you do every day in your job and in your work, that you don't have to. There may be priests that are called or pastors that are called. But those aren't the only people with a vocation, with a calling by God that or however you want to look at it. It's just that it's I'm not supposed to talk about just religious, but it is hard with, like this article is saying, is that it's hard to talk about that without religious language at least. So but I think that everybody gets that idea that you have to treat this as more than a job, both for yourself to get more out of it, and also I think we'll talk about it a little bit later, but I think it's important because of the role that attorneys are placed in.
Let me interject just one notion about one example I found recently that was kind of interesting with respect to language, where you have originally a kind of language that's religious, but then you have it in a way over time removed from the religious context and made into a purely secular term. And it occurred when I went to the Broad Art Gallery in Los Angeles with my daughter and my wife a couple of weeks ago. And it's a museum of modern art. And then they had a special exhibition on the first floor and it was called Creatures. And I was thinking, well, that sounds kind of interesting. I wouldn't expect that necessarily in a museum of modern art. And they had a kind of long paragraph definition of what creatures are. And the thing that was really striking is that there was no suggestion anywhere that creatures might have a relationship with a creator. That dimension was entirely absent. Creatures was just like beings or something like that. And I think you might have something parallel with respect to vocation, that its origin, I think, clearly does involve some kind of religious understanding. But over time, I think the term has been secularized. Now, of course, that's not to say that there isn't a genuine secular understanding of the word vocation. And that is, you don't have to be a religious believer to think that the law is something more than a job or a business. But I think one of the things that contributes to that deep understanding is precisely the fact that at one time there were religious roots. And of course, those religious roots at the time of the American founding were very much a matter of public life as well. Again, when you think of the word creature, the idea of creator, you think back to what else? The Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, endowed by their creator with certain inalienable rights. So it's not just a religious notion in the sense of a kind of private religious view, but there was a sense that there was a kind of natural theology that somehow was at the core of the American regime, the American government.
Well, so if it's not mere business, it cannot be reduced to econometric incentives and analysis, but is instead a profession occupied by professionals, and professional connotes a vocation. Where do we derive these rules? Where do we derive the framework for understanding our practice? And it's our thesis that vocation requires virtue. And again, I agree with Dr. Wolf, many of these concepts have religious roots, but they have taken binding effect in philosophy, in the humanities, and the common denominator is this concept of virtue. You cannot be a vocation, you cannot be in a vocation without a sense of virtue. And because I am the only member of this panel with no training in philosophy, I'll defer to John and Dr. Wolf on this slide and explain their perspective on the cardinal virtues.
Well, I mean, I just think it's always a good place to start with Plato, right? That he introduces us to, when we think of virtue, one of the things that I think of, what are the four cardinal virtues? Does anybody remember? Get some audience participation here.
Andrew Graham.
Temperance, justice, courage, and wisdom.
All right, there you go. So we use prudence, fortitude, temperance, and justice as our words, but you got them. Yeah, and so he introduces us to those ideas that the virtuous man or woman will have in I mean, he's talking about, right, like constructing his ideal society, right? But those are a requirement for making this more than just a job, for actually making it a vocation.
So where do we see some of these cardinal virtues in our day-to-day practice? Again, assuming most of you practice in Texas, you're licensed through the Texas Bar. Let's peruse the Texas disciplinary rules of professional concept and see if we might find evidence of virtue as at least a concept. We think you see prudence, which we define as the right reason and action, knowledge of reality and realization of the good. We'll look at Rule 1.03, communication. A lawyer shall keep a client reasonably informed to make informed decisions regarding representation. In other words, the prudent lawyer looks to the interest of their client, not just their self-interest. If you ever read the back pages of the Texas Bar Journal, you'll see the quickest way to get disbarred is to fail to communicate with your client. In other words, you fail to care for them. You fail to invest in their good, not just yours. That is the quickest path to disbarment in the state of Texas, at least as I can ascertain from reading those pages. we see prudence, a principle of prudence, fertilized in that rule. Look at Rule 2.01.
Advisor.
In advising or otherwise representing a client, a lawyer shall exercise independent professional judgment and render candid advice. Recall back to some of those classical texts. We don't just tell you what you want to hear. You know, we are not the vendor on the corner who will sell you a hot dog and promise anything to get that dollar bill in exchange. Sometimes we have to tell our clients things they don't want to hear. The law is against you on this one. I don't think the facts are good. I think if you pursue this through trial, as angry as you are, you're going to lose. So there's this counselor role that you see baked into 2.01, and I think that sort of counsel requires prudence.
Okay, so next, fortitude, we kind of defined as firmness in difficulties and constancy in the pursuit of the good. So a couple of examples here. First, lawyer's witness. A lawyer shall not accept or continue employment as an advocate before a tribunal if the lawyer knows or believes that the lawyer is or may be a witness, right? So that's a very common sense rule that you don't want to place yourself into that role. In 309, special.
Yeah, since I'm a former prosecutor. 3.09, special responsibilities of a prosecutor. Refrain from prosecuting or threatening to prosecute a charge that the prosecutor knows is not supported by probable cause. There are many AUSAs and ADAs who would not have lost their bar license had they heeded this principle. The idea that you have a special vocation as a prosecutor. You are entrusted with the coercive power of the state. You cannot use it to bully people. You cannot use it to engage in malicious prosecution. And so as a former AUSA, I really like this one because I think it's important. Prosecutors have a special responsibility. They hold the keys to the grand jury room. And in many ways, we hold the keys that can get you out of jail. If you don't have a proper sense of vocation instructed by the virtues, you'll see the scandals that you see when law enforcement is abused.
And I think, right, like, so this is fortitude, or like Andrew's saying, you know, it's courage, right? That sometimes you get placed in these situations where, you know, a partner or a client or a judge, right, is even maybe you asking, or you think they're asking you to do something that you know that you shouldn't do. And that's kind of the point underlying these rules, is that it's going to take courage sometimes to say no to what you shouldn't do.
So I served
In the appellate division, and there were many instances where we had to say no to an indictment because the law didn't match the facts. We knew that there was something wrong. We knew there was wrongdoing, particularly, without citing any case-specific examples, healthcare fraud. It's so complicated. The coding and the regulatory infrastructure is so Byzantine. You can find abuses everywhere. And we know there's wrongdoing out there. And some doctors are just smart enough to skirt the rules and survive. There were times where we had to tell prosecutors who were full of justice and wanting to punish wrongdoing that the law just didn't match. We can't defend this on appeal. That's not our system. Let's move on to a different case. That takes fortitude.
So temperance.
We define that as, well, we don't define it, we derive it. Keeps desires within the limits of what is honorable. 1.04, every client will love this one. A lawyer shall not collect an illegal fee or unconscionable fee. A fee is unconscionable if a competent lawyer could not form a reasonable belief that the fee is reasonable. 3.01, meritorious claims and contentions. A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless the lawyer reasonably believes that there is a basis for doing so. That is not frivolous. This sort of is the civilian version of the prosecutor rule. You don't bring non-meritorious claims simply to gain an extra few yards on the football field. 3.02, minimizing the burdens of delays of litigation. In the course of litigation, a lawyer shall not take a position that unreasonably increase the cost of other burdens of the case or that unreasonably delays resolution of the matter. Here I think back to my days in private practice, vexatious discovery. Do you continue to pound the opposition with quadruply redundant interrogatories, requests for production? Like, at some point, you do cross the line. And here, I think the line correlates to temperance.
So the last one, of course, the one that attorneys probably most think of when applying virtue to our profession, is justice, right? So right thinking and uprightness of conduct toward neighbors, the other. And so I think this kind of captures for me what I think of when I think of justice. I think of, it's a lot of ideas, right? And of course, I think we're going to talk about it here in just a second, that people do have a lot of different ideas about justice, and a lot of books have been written on this. But I mean, it's a fairness, and it's a working toward the common good, right, of everyone. And I'm not going to read these because I think we're going to let's speed up just a little bit. Maybe we have time for questions. But we did want to focus on this question: that what is justice? Because I think that is the key virtue for an attorney.
Okay, so I used to work for the Department of Justice. Justice, if only we knew what it was. Funny quote from Socrates. My former employer, the Department of Justice. John Rawls, A Theory of Justice. Thomas Sowell, The Quest for Cosmic Justice. Earth Justice, because the earth needs a good lawyer. The Asian Communities for Reproductive Justice. Justice is one of those God words in the American vernacular that can be deployed to silence dissent or to silence the opposition. Well, you cannot oppose my position because I stand for justice.
Yeah, and sometimes I think, and we won't ask Judge Garza to confirm, but there was an apocryphal story when I clerked about that there used to be a judge that he would come to a case and maybe he just really wanted one party to win, really just felt that this party should win, and so he might say to his clerks or whoever, like, let's just do a little justice here, okay? And what that meant, that was his code for, we're not really going to write an opinion on this. This is going to be just a per curiam, just rubber stamp whatever the district court did, because that's what he felt was right in that instance. And so
we bring it full circle here, back to our points about linguistic relativism, the decline of language and objective rules of language. Thomas Sowell, if you have not read The Quest for Cosmic Justice, it's a must read. It's one of his most famous lectures that he turned into a book. And it's basically a rejoinder to John Rawls, A Theory of Justice. One of the few subjects on which we all seem to agree is the need for justice, but our agreement is only seeming because we mean such different things by the same word. Whatever moral principle each of us believes in, we call justice. So we are only talking in a circle when we say that we advocate justice, unless we specify just what the conception of justice we have in mind. And so this is the problem of definition. This goes back to our point about language. It's very difficult to articulate a common ground of virtue and virtuous concepts unless we give definitions to the concept. So historically, justice kind of has at least 4 versions. There's the punishment context. You learned about that in criminal law. There's retribution versus rehabilitation, restoration, reconciliation. There's economic justice, redistribution, distributism, and other concepts. There's sort of what I consider the most classical, traditional definition, and this is what Thomas Sowell talks about in his book, process. It's notice, hearing, jury, appeal, opportunity to be heard. And then this is what I saw most of in law school, this sort of cosmic justice. You should manipulate words, the system, the courts, due process, the living constitution, whatever, to eliminate undeserved disadvantages for select groups. And I give some examples here that prove the mere incantation of the word justice is insufficient to define the concept and then apply it with force to the people who are bound by it. So we have to first, I think when we talk about these concepts, we have to be very careful to achieve disagreement. Now that I work in the nonprofit sector doing religious liberty work and constitutional work, there are a lot of talking points that just fire past each other. Justice, equality, all the God words are used in these little sound bites that we see on Fox News and CNN. But it's really important to to achieve clear disagreement about these concepts before we can just invoke something like a concept like justice. So how do we do it? How do we take these virtues? Sometimes there are competing visions of it, and apply it.
So there was a quote that didn't make the slide, but I liked it. It was the quote was justice. Basically, you want justice. You got to wait till heaven, right? Here on earth, you get law, and I think that's one thing to think about, right? Is that we don't have a perfect system. I mean, there have been different systems throughout history. We don't have, for instance, an inquisitorial system, right? So we know going into, say, a criminal trial, a criminal context, we're not going to make the accused testify against himself. We may even, to Matt's chagrin and mine, exclude evidence. Right? In certain cases, we may purposefully, stick our head in the sand concerning evidence. We're not always going to get at the truth per se, but that's not our system, right? So I think that's important to remember, because we're talking about following these. Gave you some examples of some rules where Texas is trying to give you an idea, like, okay, here's what it is to be an ethical lawyer. Maybe follow these rules, and I think that's good. That's a good starting place, but that's not enough, because there's got to be. So that's why we're trying to introduce this concept of virtue to the calling, and that's seeking justice. Like Matt said, it has to be in conformity with the common good. And even when we don't agree on that, we can think about the things that we do agree on, the things that we have agreed to, like our processes, our certain rules that we've set in place in order to accomplish these goals. I mean, that's why when that judge, may not have even been true, but let's say that it was, said, let's do a little justice, he was actually not doing justice, because he was going outside of the prescribed bounds and rules that we have agreed to work by. And so we wanted to just show you one clip here. I was going to set it up. You remember our founding father, John Adams, was tasked with something very difficult when the British soldiers who were responsible for the Boston Massacre were being brought to trial, and they looked around and they couldn't find anybody to represent these guys. Nobody wanted to do it. Why? Because they've just shot Crispus Attucks and these other guys in the street, and the mob just wants to string them up right then, right? And so I think they would have even maybe been fine with basically a kangaroo court at that point. But John Adams steps in and takes on this role to defend these soldiers, and I think he shows several of the virtues here, if not all of them. But knowing that it's something that may cost him monetarily, maybe nobody wants to hire him anymore, right? He has a wife and child, and this is an angry lynch mob, right? So I mean, it may be physical harm that could come to him or his family, but he steps in because it's the right thing to do. So.
Yeah, so we think this is virtue applied in a real form, in a real person, John Adams. So I think that's, I note the irony here. I'm the former prosecutor playing a clip of a really great criminal defense attorney. But I have Cass in the audience, so it's apropos. If you hollow out the profession of virtuous men, you lose this. You lose the John Adams who will stand athwart the angry mob and defend the rule of law, the application of the rule of evidence, the rules of evidence to defend the accused. And when passions are at their highest, that's when virtue must match the passion. And so this is one of my favorite scenes from John Adams, and we think this is a good example of virtue personified.
Right. And so, like, I know we're probably preaching to the choir here today in some respects, but just wanted to close with a thought on why this is so important. And I think it's because attorneys are given the power to pull the levers of society that affect life, liberty, and property, the common rights to which everyone is entitled. And And I think probably Judge Garza will speak to some of this. I think because we're very attuned to that when it's a judge, right? We're thinking that they need to be virtuous because they have this power over people, which they do. But I mean, I think it's more than that. It's all attorneys because of the intimate relationship between an attorney and the great power with which we're entrusted in being able to affect these levers. And I think that demands the exercise of virtue in carrying out the responsibilities of the profession. It demands that our profession be a vocation and not just a job.
And with that, we'll open up the floor to questions.
From the audience, questions? Yes.
There was one sort of almost presupposition, and I didn't think you played it out, and I'll give you a chance to, because I'd love to know. For vocation, you said virtue is required. For somebody who is not a believer in God, is there a logical reason why that's necessary, or is that just for people who believe in the Creator?
I think you everyone benefits from a belief system that holds that there are absolute principles that are not subject to the whim of the powerful. And I think those roots are firmest in religion. I do think people can derive the same principles philosophically, metaphysically. I think you can adhere to those truths through other systems, but I think they are best rooted in the soil of religion because there's this concept of an absolute.
Yeah, I mean, I think you're right, Kelly. I almost put the why piece in there earlier because there was a logical gap. But I think it ties into what I was saying there at the end, that just because attorneys are given just such intimate relationship with and control over life, liberty, property, the things that everyone in our society for the common good has agreed are the foundational rights to which people are entitled. That I don't think that, again, it helps, and it's hard to, as we've discussed, talk about any of this without religious overtones in the language, but that it is possible and indeed even necessary and provable that you do need virtue in being an attorney because of with great power comes great responsibility, right? Spider-Man.
So I have two maxims I can deploy here. All truth is God's truth, or even a blind squirrel finds a nut. And so if it is true, it should prevail, and it can be revealed to people who may not even know its origin.
One thing I'd like to interject, I mean, the American Public Philosophy Institute is, as I said earlier, oriented especially toward natural law. And it has this conception that really all human beings know certain fundamental moral truths. You know, sometimes they can be blinded by passion or bad customs or something of that sort. But basically, virtually all human beings know certain fundamental principles. And it's because we have an understanding that some things are good for human beings and some things are bad. You know, there's some kind of conception of the human good that we have. And there are lots of different goods. And that's really the foundation for really understanding natural law. And you see this in just very elementary things. The youngest kid, sitting there playing with his toy, some other kid comes along and takes the toy and walks away. I mean, is that simply the self-interest of the child wanting that toy? Or do we all have some fundamental sense of fairness, justice, something that transcends any given person's individual self-interest? I mean, there are people who doubt that, but I think, in fact, our society is deeply rooted in this idea that there are principles of natural justice. There's a kind of natural law that all human beings have access to. So, from the standpoint of law, even if we thought of law as a religious calling, how much guidance would we get from specifically religious sources? Do we want to actually go back and rely on the juridical precepts of the Hebrew Bible, to figure out what a good lawyer is? Probably not not so much. It was a very different kind of entity, Israel in the Old Testament. Most of even what religious people call, let's say, legal ethics, would be really things that are derived primarily from the natural law. And of course, in a pluralistic society, this is profoundly important, because you don't want to, even if you're a religious believer who especially kind of cherish the religious foundations of your morality, in a society like our own, where there's so many different religions, you won't want to go out and start citing the Bible. Not that it's bad to do that. People do cite the Ten Commandments. Even the Supreme Court will tolerate it on the Texas state capitol grounds. But the point is that we're living in a nation where people have many different views, and so it makes sense to go to that set of views that originates in natural law, which is really based on reason and which doesn't require a particular religious commitment. And so I very strongly kind of second what was implicit in the question, which is the importance of having an understanding of the rational basis of virtue and moral principles. And I think that's something that in the course of American history, Americans have generally been very sensitive to. I think there has been a strong sense of natural law, whatever our debates about particular parts of it throughout U.S. history. It's really, as some of the introductory material in the PowerPoint suggested, it's really, I think, into the 20th century, before you get really strong public presentations of much more philosophically skeptical views, which I don't think you had so much earlier in American history.
Let me just,
Yes.
if you stick around, I might help a little bit on that. I take a little different view, and stick around.
So, because I've given a presentation on virtue, I should bind myself to virtue and applying principles of charitable interpretation. I don't think my adversaries are blind squirrels. I actually regret saying that joke. What I meant by that is there is this, the Christian tradition will speak of the law written on the heart, what you cannot not know. And I think that is intuitive to our species. These certain principles. Now they take more sophisticated form in the writings of the Greek philosophers that we saw at the beginning, and then the impassionate opening defense of John Adams. But yes, I'm in agreement with Dr. Wolf that there are these things you cannot not know, and we seek to codify those in rules. But the rules are worthless if you don't imprint it on the human heart. And in that, when the heat is applied and you perceive that you can gain advantage by lying, you can gain advantage by filing an unnecessary discovery motion. You can maybe selectively cite a case and not use the right signals that will let the judge know that there's a contra that should follow. It's a death by 1,000 cuts.
There's a lot of use of CFs in briefing.
Exactly.
Yeah.
So
eventually they become C alsos.
Without identifying any individual practitioner, of course, when I was a prosecutor, I observed this with a confrontation clause. The Supreme Court decided Crawford versus Washington and then Melendez-Diaz, and the court reaffirmed a very robust constitutional trial right to confrontation. I saw practitioners very selectively citing to Crawford, very selectively citing to Melendez-Diaz for their right to confrontation in a supervised release revocation proceeding, which is administrative. It's a Fifth Amendment proceeding. It's completely different. But they perceived that they could get, and this is what I was talking about, magic word briefing. They perceived that they could maybe persuade the judge to extend the law beyond its reach using magic words that sound good. And if the practitioner doesn't chase the citations to the end, that's where the rule of law slowly dies, is people for that moment of weakness, misrepresenting what the law says to the court. You should take seriously your obligation, not just to your client, but to the judge and the bar and the court. So that has to be written on the heart.